Be ready. 5 seconds. Start. The attachment may not necessarily be of the property itself but of the right title and interest of the debtor in the property at the date of the attachment. Stop. An attaching creditor can only attach the right title and interest of his debtor at the date of the attachment, and on principle his attachment cannot confer upon him any higher right than the judgment debtor had at the date of the attachment. Stop. If a person having a contract of sale in his favor has such pre-existing right, the attachment could not be binding upon him. Stop. If the promise gets a conveyance after the attachment in pursuance of his contract, he takes a good title in spite of the attachment. Stop. Mr. Ravi Gupta, Learned Counsel, also referred to Section 53A of the Transfer of Property Act 1882, which reads as under para, where any person contracts to transfer for consideration any immovable property by writing signed by him or on his behalf, from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty, and the transferee has, in part performance of the contract, taken possession of the property or any part thereof, or the transferee, being already in possession, continues in possession in part performance of the contract and has done some act in furtherance of the contract, and the transferee has performed or is willing to perform his part of the contract, then, notwithstanding that the contract, though required to be registered, has not been registered, or where there is an instrument of transfer, that the transfer has not been completed in the manner prescribed, therefore, by the law for the time being in force, the transferor or any person claiming under him shall be debarred from enforcing against the transferee, and persons claiming under him any right in respect of the property of which the transferee has taken or continued in possession other than a right expressly provided by the terms of the contract. Stop. Provided that nothing in this section shall affect the rights of a transferee for consideration who has no notice of the contract or of the part performance thereof. Para. Mr. Ravi Gupta, Learned Counsel, thus contended that the principles of the said provisions would squarely apply in the present case, since contract to transfer is for consideration is duly signed and possession has been taken in part performance of the agreement to sell, under which full consideration has been paid apart from the execution of collateral documents, being the agreement to sell, general power of attorney, special power of attorney, will, etc. Stop. It is thus contended by Mr. Ravi Gupta that at best the bank will step into the shoes of any person who is the transferor, which would debar the bank from acting in a manner which will have the effect of enforcing against the appellant who is the transferee any right in respect of the property of which the appellant has taken possession other than a right expressly provided by the terms of the contract. Stop. Mr. Bakshi Bikram Singh, Learned Counsel for Respondent number 1, on the other hand, has contended that the conclusion arrived at by the learned single judge is right, and has relied on the provisions of Section 54 of the Transfer of Property Act to contend that no rights had been created in law in favor of the appellant in pursuance to the agreement to sell. Stop.